Okay, well, good afternoon, everybody. And this is the anchor presentation. So we're going to try to make it around the gun lap in good shape, and we're going to keep it fast and lively and encourage lots of questions. My name is Steve Gannon. I'm a shareholder at Murphy McGonigle. It's a law firm. I practice in Virginia and DC. We also have offices in New York and Chicago and San Francisco. We do a lot of work in the crypto space. Mostly we're a financial services firm. We started out as a securities litigation firm, and we went into commodities, then markets, then crypto, and now and I'm pretty much a banking lawyer. I was recently general counsel of Citizens Financial Group in Boston, joined the firm a few months ago, and we are highly interested in this space, thrilled to be in Wyoming, could not be in and by the way, the presentation that Matt made is like the perfect setup for our presentation. Rodrigo.
Hi, everyone. Thank you so much for being here. My name is Rodrigo. I'm an attorney at Cooley, which is a tech startup law firm based out of Seattle. We work with entrepreneurs from all across the US. And I've been focused on working with crypto entrepreneurs since like early 2017. And I work with lots of folks kind of like in the NFT space, a lot of token issuers, work with a lot of companies that are raising money, actually including financings, and more recently been working with a lot of DAOs to try to kind of set up different organizations for their operations, both in the metaverse and in the meat space, and trying to help them with financing events.
All right, so we're gonna start, by the way, with the title of this presentation, which is Defi and Regulation at the Crossroads. What color is the traffic light? By the way, that was a trick question. There is no traffic light, so let's start with that. And the Crossroads, though, is a very, very real one. And the way Matt set it up really was, I thought, incredible. It's pretty amazing when you think about autonomous organizations that are decentralized, like DAOs are, because think about a regulator coming to an organization and asking who's responsible for a particular act, and everybody raises their hand at the same time, sort of like an I am Spartacus moment. But here's the challenge. The 1933 Act, which is sort of where we begin in terms of regulation, is 80 years old. It was written by four men, the youngest of whom was born in 1900, and it was voted on by a Senate, 73% of whose members were born before Edison invented the electric light bulb, and 60% of whom were born before Custer's last stand. So it's not exactly a framework that is up to speed with what's going on today. And of course, that sounds like cocktail party trivia, and it is a little bit, but also it makes the point that financial services regulation today is being seen through and viewed through a very old set of eyes. Meaning assumptions about how the world works and should work, its strengths and risks, and it's assessed by those who have always experienced a deeply intermediated financial system, which has always contained elements of operational fault tolerance, such as recallability for wires, aged technology stacks with compensating controls one on top of another to mitigate multiple potential points of failure, discount windows, lenders of last resort, collateral substitutions, market makers creating uncovered shorts, clearinghouses allowing temporary settlement failures. You get the idea. Much of this is sort of normal course of events for regulators, and that way of thinking is not consistent with neither the technology that's in place now, nor the underlying movement that's pushing it forward. Rodrigo, I'm going to pass it over to you to sort of have you give a framework, because part of this discussion is a little bit philosophical. Have you give a sense of the framework that you think is happening right now?
Sure. So in kind of thinking about crypto regulation, one of the kind of frameworks that I found most helpful and one that just seems so obvious after I was exposed to it is the framework developed by this Venezuelan economist named Carlota Perez, in the book titled Technological Revolutions in Financial Capital. And in what's like a really tediously researched book, what she does is she looks at the kind of five main technological revolutions. So these are things like the telegram, electricity, and then tracks how financial capital was able to kind of invest into those technologies and help them grow. And the fundamental point that I take from this, and that she explains in her book, is that she divides up, or she considers the relationship of the existing regulatory paradigm and these new technologies as they develop, and basically comes with the idea that the existing regulatory paradigms are all developed based on the fundamental technology of the time. And what that means is that as new technologies develop, the existing regulatory system will act as an exclusionary device and kind of push those new technologies to the fringe. And what that does, right, is it allows them to develop, and it attracts capital because that's where the biggest yields are. And it allows them to develop outside of the regulatory system up to a point where which determines that there's a rupture, some sort of like dramatic event. So you can think of like a crisis, that realigns those two things and brings a new kind of regulatory paradigm that is built kind of to reflect that new technology. So I found this kind of insight really meaningful, and I think it kind of illustrates the point where we're at right now with crypto regulation. So the securities laws are notably antiquated, but they are very flexible, right? And for example, Howey is a test that really looks at kind of like the underlying economic relationships, and has been applied to everything from like cask of whiskey to like the orange groves in Howey to like chinchillas. So they can really be very, very flexible. But I think what this new technology is really like bringing to the front is whether we have a new paradigm shift in the way that we interact with each other that really is like fundamentally at odds with the way that we've been thinking about regulation in this space, right? And I think there's a couple of examples of that we're starting to see. I think DAOs are kind of probably the main example of that. In a way that you can see people kind of like anonymously come together from all over the world and be able to collect capital and deploy capital and act collectively in a way that like really wasn't possible before, and in a way that doesn't really require the intermediation that a typical business entity had. It's somewhat different, but also kind of brings up the tension. Something like Coinbase Lend, which I'm sure everybody here has heard about, or the different kind of interest bearing or yield producing products that are now prevalent in DeFi. Really hard to kind of fit into the box, and like they kind of look like securities if you apply Howey to them, but it's more of like a bank relationship. So I think kind of taking this framework of kind of what it is, where she thinks that regulation is first excluding a new technology, and then that leading to that technology evolving outside of it, and then a rupture point coming. I think really that's kind of where we're starting to, where we are right now, and where we're going to face in the future.
So that's, by the way, that is a great explanation, Rodrigo. And when you kind of envision that, it's sort of like all these wonderful possibilities coming into the crossroads that we were talking about in our title, but also coming at the same time is the body of regulation. And one of the things, yes.
I was just going to ask, is that rupture almost exclusively a negative event that would then lead those authorities to protect consumers by putting those regulations in place? Or could it be a positive sort of rupture where they say, hey, we need to legitimize this system because look at the positive benefits of it?
So I'm trying to think back at the historical examples, and I'm not super fresh on them, but I don't think it necessarily needs to be negative. I think what it really is like a point where the thing that's been developing outside becomes so big that it can no longer be kind of ignored and shunned as a fringe thing, and it becomes kind of the main technology of the time, right? So I don't think it needs to be positive or negative. It's just I think it's typically just like a dramatic kind of like, yeah, some sort of.
Yeah, I'll sort of riff on that a little bit. I think it's both things, but it depends on who is sort of doing the thinking. So you have a number of different thoughtful individuals and thoughtful organizations that want to make sure that the innovation advances. And they see it not only from the standpoint of just it makes local sense, because innovation and advancement, and particularly this kind of advancement where costs are being lowered, friction is being taken out, more people are being included, it makes a lot of sense. So you don't want to crush the butterfly. Senator Lummis, by the way, happens to be one of the most thoughtful people in the country on this. And she's the co-chair of the Senate Financial Innovation Council, and they're doing some great work. However, one of the things we said we were going to do in this talk is synthesize some of the other views. And I'm going to try to do that now with if you were here for Angela Scoba's Wilson's talk. She said that the regulators didn't have a harmonized view around how they were going to regulate. And actually, I'll challenge that a little bit in this way. So agencies have all sorts of different agendas. So you've got financial crime, that's DOJ, Treasury through FinCEN. You've got investor protection, SEC and CFTC. You've got consumer protection, OCC, CFPB, the state AGs. You have financial stability, the Fed, FDIC, OCC, maybe the state banking commissioners. You've got tax interest with the IRS. You've got governance with the states, and also to a certain extent, social policy. But I'd suggest there is one harmonizing principle behind all that for the regulators. And this is what makes this crossroads pretty difficult, and that is preserve my jurisdiction. I want to make sure that my jurisdiction is preserved. And oh, by the way, I wouldn't mind expanding it and taking, jurisdiction from some of these other folks. So what does that mean in terms of the crossroads, my view and no one else's? I think it means that meaningful legislation might be tough. Because it's going to be, we have a very fractured regulatory system. All of those folks have interests that are represented on the Hill. It's going to be tough to compose all of those differences. And so I think that's going to be a kind of a long road ahead. And I think if you, there was a fireside chat a little bit earlier that Steve was involved in, where one of the points of discussion was that one of the likely outcomes of all this is there's going to be an effort by each agency to expand its regulatory perimeter, sort of at the cost perhaps of the decentralized finance community and the blockchain community, which means that what that gets down to is things like regulation by guidance, regulation by enforcement, et cetera. So we'll be fighting for a while. It's not going to be a short contest. Rodrigo, anything to add to that?
So I mean, kind of your question got me thinking more of like applying the context to like the crypto context and what I could see as the potential pressure here. And I think one of the kind of complicating factors in this model, and I think one of the things that makes regulating the space and adapting to it so difficult is that I think you're I guess for the first time really seeing a activity and a technology that can be global and scale in a way that it wasn't really possible before. So I think in a way it's not really only a local regulatory response that needs to happen, right? It needs to be kind of a coordinated response of all regulators. And I think you also face this duality of either trying to regulate it in a way that kind of encourages it, but also keeps it within the bounds, or risk pushing it to like the darkest corners of the internet, where it's anonymous founders with frog emojis, frog avatars, and that's what you're dealing with. And I think for the first time, this technology kind of really allows that at scale, at scale not only internationally and the number of people, but also like economically, right? Like you can really move a lot of economic power around this way. So yeah, I don't know if I have the answers, but I think that's why I'm so excited to be in this space, because I really do feel like it's coming to a head in a way.
Yes.
In early August, Gary Gensler did a interview with the Aspen Institute where for national security, and among other things, he mentioned that the SEC was having a hard time recruiting and retaining capable regulators that are, crypto savvy. It seems obvious because if you're savvy enough to regulate it, you'll go out in the private sector and do something else. Do you have any instinct on whether that is a contributing factor to why we're seeing kind of regulation by litigation?
Absolutely. I think that makes, number one, it makes perfect sense. So in order to develop policy, you need expertise. And that's one of the things that has been brilliant about what Wyoming has done. It's taken its time, it's been thoughtful, et cetera, et cetera. Gensler is starting from a set of starting blocks where all of a sudden he doesn't have, I believe, in his view, the sort of time, if you will, to sort of set a pace and then, get stronger with each lap. It's like a sprint from day one. It's going to be very difficult to get the kind of talent that he needs to do the sort of analytics to develop the policy in-house. So what's being done? Well, they send a well submission, right, to Coinbase now, and they continue their litigation with Rebel Labs. So that's unfortunate because it's very herky-jerky, and regulation by enforcement is not ever anything you can really particularly rely on because it changes case by case by case. And what I worry about a little bit is what's going to roll out instead is going to be a series of guidances, if you will. And by the way, the guidances have literally zero effect in terms of the rule of law. They are not law, and they can't be depended on to file an enforcement action. So you're going to be in this weird sort of shadow world where what really needs to be done is good policy needs to be developed, and that policy needs to be taken to the hill, and then that needs to be implemented. Or in the alternative, you could go through the rulemaking process through the APA where the public gets to have a say. So, sorry for the long answer there. Yes, ma'am.
The SEC has given a grand total of 3 no action letters in, all the years that this conversation has been happening. And they keep saying, come in and talk to us.
Yes.
Okay. And those no action letters took 18 months plus and hundreds of thousands of dollars of legal fees for those who got them. How do you square that circle? Is there anything that can increase the likelihood that the SEC or the speed with which the SEC gives no action letters so that their guidance can actually be relied upon?
Go ahead, Rodrigo.
I'm going to be careful. So I actually worked on one of them, the pocket full of quarters, no action letter, with Lewis Cohen at DLX. If you look, I frankly don't think it's really a viable means to get like a project off the ground because, like you said, it takes a long time. I mean, I think that one took us like over a year.
Yeah.
Lots of very sensitive meetings. And they take a uber conservative approach. If you look at all 3 of the no action letters, I mean, they've all been criticized for basically saying that they were in no one's mind were they ever going to be securities, right? Because these are all basically tokens, right? That are like, I mean, the pocket full of quarters is like it's like an arcade token basically, and it's not tradable in the secondary markets, and it can't appreciate. So I think those are the 2 main things that the SEC has really focused on. It's they're not going to get, at least in my mind, under this administration, any no action to any token that is tradable or like can appreciate. Even though I don't think that's clear from the law that you can't have a product that has those 2 features, right? And then I think the broader point, which I want to push back a little bit, is this idea that you need to go into talk to the SEC about doing a private securities offering, because there is, the registered securities offering route, which is the one kind of path where the SEC has authority and the right to kind of like approve a registration before, right? And that concept doesn't really apply in private securities transactions as long as you comply with the exemptions, right? So you can file a Form D after the fact, but there's no, ex ante, you need to go in and get blessed. And I think while on some levels, this is the SEC trying to be helpful and engage with the community and get guidance, it also feels a little bit like expansion of their jurisdiction and a requirement that you get approved for like a private placement, right? In a way. So I think it's a tough, it's not something I see a lot of companies doing now.
So, well, Caitlin, I'm going to answer that in a slightly different way. The question was, is there anything you can do to make the SEC move faster on these? The answer is no. But the underlying reason in my mind is it's a cultural reason. There's no motivation for the SEC to move fast on these things. There's every motivation to move slow, because the last thing you want to do if you're working on a no action letter is make a mistake. And so multiple sign-offs, always requests for more information, more documentation, more edits, et cetera, et cetera. So not much you can do.
But just to follow up, here's the problem, right? The law is not what's written in the books. The law is whatever somebody's willing to spend to test the enforcement of
Right.
regulatory agencies' authority on what they think is the law, right? Okay, so if we acknowledge that, then well, there are a couple things. One is, can we rely upon the statute of limitations to having passed on some of these coins? And is somebody actually going to start a fund to invest in clean coins that never got that never got pursued by the SEC? Let's start with that.
The answer is you can rely on the statute of limitations. And in some cases, and I'd have to look at the statute, they're actually, after a certain period of time, they become a statute proposed. So you can't challenge them, period.
Right.
So in other words, to
Well past that.
to try to bring an enforcement action against something that had passed, the statute of limitation that passed would be in bad faith.
Okay, so that's the one thing we can rely upon.
So my gloss on that is the SEC and Securities Act, they regulate transactions, right? They don't regulate the objects. So, and the SEC has also given credence to this idea that you can mutate between security status and not. So I don't think that just because the statute of limitations has passed on the initial ICO, it means that they can never be securities, right? But to your more general point, I think it's kind of sad that we're required to try to look at all these different kind of like measures to try to like back into whether they're securities or not. Like a lot of the folks that I deal with, they're like, oh, if it's listed on Coinbase, then it's probably not a security, right? Because they're a public company and they have some SEC oversight. But yeah, I hear you. Like as a practicing attorney, it's super hard to give any practical advice because it's pretty mushy. And then I do think that there's a gap between what the law will ultimately be after it's tested in court with like capable counsel on both sides and like some of the positions that the regulators are taking these days.
So what's your perspective on the fact that the SEC let Coinbase go public and now 9 months later is saying most of the things that trade on Coinbase are securities? Why did they let them go public?
I'm going to pass on that one.
Well, I'll give an opinion on it, which is that they would say that they're not, when they are letting a company go public, they're not giving an opinion on whether the company is going to engage in future actions that might or might not be problematic. They just did the appropriate filings, did the appropriate disclosures at the time that fulfilled all the forms under the 33 Act, et cetera. So that usually is not I hear your frustration. I'm
That's
sure.
going to be a fun one to defend on CNBC.
What if I define it as a blackjack table? Will they leave me alone then?
Say again?
So if I just define the fund as a blackjack table, will they leave me alone
Will
then?
they leave you alone then? I don't know. They're not in the habit of leaving people alone. They, yes, Beck.
Do you see the SEC continuing to target companies like Library in the future? Library Coin?
Yeah, I mean, I think everyone that's paying attention to the space is getting ready for like an onslaught of enforcement actions. Like if you look at,
It just doesn't seem like an SEC area. If they're going to attack the Library Coin, why not Bitcoin, Ethereum, every digital coin?
Well, it goes to what I said earlier. They're trying to expand their regulatory perimeter.
Why though? It just doesn't seem like something they should be meddling in.
So I think they will take the position that it's an unregistered securities offering, right? And it is within the jurisdiction to regulate markets. And I think they kind of exempted Bitcoin because of its immaculate conception, if you will. And Ethereum kind of got grandfathered in because it was a huge industry by the time they were like, thinking about it seriously. That's my frank assessment.
What do you mean by people's frog avatars?
Right.
You said unless the government regulates every coin in existence, then it'll be left up to people's frog avatars. What do you mean by that?
I just meant like if I think in this space, there's a risk that if the regulation is overbearing, people will like flee to the dark corners of the internet, and instead of dealing with Coinbase, you'll be dealing with a bunch of anonymous people, and frog avatars was my attempted humor. And just
It was well taken. That was very funny.
So it was just to say that if you clamp down too much, it's going to become even harder to regulate because it'll move out to the edges and offshore.
Yes.
I'm just curious, when you kind of think about the SEC regulatory environment, they've not come out and approved, obviously, an ETF, but what we're seeing now is a lot of these trust structures come out. GBTC, Osprey has one, and now they're going into where Osprey has one on like Solana. So, coins that basically were, I think, initially done outside of the US, then started trading in the US, and then have a trust structure. How do you kind of reconcile the trust structure that's been allowed to trade versus the fact they won't let the ETFs trade, and how they kind of bifurcate or pick winners and losers here?
I can't tell you what the thinking is about the ETFs, other than what I would say is sort of a little bit like what my response was earlier to Ms. Long, which is the SEC hasn't quite figured out what its policy is going to be with respect to ETFs. So it's just extending the game. They're going to play the 10th inning and the 11th inning and the 12th inning. They're just going to keep the game going until they make up their minds on exactly what they want to do. Trust structures are something that they're just more familiar with. They have jurisdiction over the Trust Indenture Act. I think they just feel more comfortable with the structure. That's all. Yes, sir.
Just as a follow-up to that, the incentive that the federal regulators have set out is to pursue the so-called West Coast ask for forgiveness rather than permission approach. And those that have asked for permission before forgiveness just get iced. And you see the problem, right? I assume they see the problem.
Yes. They don't see it as a problem.
They see it as, well, okay, but the fact that they haven't gone, they haven't taken enforcement actions against any of the lending programs that are proliferating, and then they suddenly drop the bomb on one that was easy for them to do because they're a registered registrant.
Yes.
How do they square that circle? Are they going to come with a massive amount of enforcement actions and suddenly drop enforcement actions on thousands of companies at the same time?
So I'm going to speculate now, and
Yeah.
for anybody who watches this is just speculation. But there is history can be a guide. And if you look at other enforcement programs and how they've been managed by the Division of Enforcement, basically what they do is there'll be public notification, if you will, through speeches, through guidance, through notices from, OC, stuff like that, about this is how they would like the registrants to act. Then as the conduct continues, then there will be settlements. So there'll be negotiated settlements. So to a certain extent, they already got a small victory by, Coinbase backing off on lend, right? And so my anticipation would be that there'll be, Coinbase is pretty big. There'll be smaller organizations where they'll get similar settlements. The orders in connection with those settlements will, although the orders, by the way, they are not precedent. Let me repeat that, they are not precedent. The orders, however, will articulate the SEC's position. And then after they've got enough of them, they will say, hey, guess what, guys? We're going to have a program in place. It's going to be a programmatic settlement. All of you in this particular space, you can settle on these terms. The fines will be very reasonable. You'll have to agree to, there'll be several years of monitoring, et cetera, but, we'll go easy on you. And after all, this is the standards that we've articulated, and we have all these settlements, and their view will be that they're just telling you what the law is. But it's just a way to kind of build momentum.
That's how they'll get whole chunks of this industry at the same time.
I'm speculating, but they've run that playbook in the past.
Yeah.
They do like sweeps, right, where they will send letters to everybody, and it starts as an informational request, and then it can escalate to a subpoena, and then they'll take bad actors out of that.
Yes.
So we've seen in other industries like cannabis where there's the clash between state law and federal law, where the regulators are trying to oppose federal, and then state actors will fight back. They'll reverse the attack, right? So do you think it's possible that a Wyoming company will act first and say, hey, we see this coming, we're going to sue the SEC or sue the regulator before they bring this kind of what you described?
You raise a very good question of federalism. And will Wyoming or Wyoming entities believe that the federal unclear regulatory scheme, or perhaps less than specific standard regulatory scheme, is that something that is getting in the way of the state exercising the power that it's allowed to have under the 9th and 10th Amendments? And quite possible that would be the case. It is an interesting sort of intersection of federal and state law. If Wyoming, for example, there could be other states, but Wyoming has the most highly developed set of statutes and regulations right now. If Wyoming allows an entity to do certain things, empowers it to do certain things, and the federal government stands in the way, but it doesn't have any constitutional basis to do so, then at a certain point, the federal government is impeding the state government in exercising its powers. That strikes me as a constitutional problem.
I think, can we unpack that for a second?
Sure.
So if we put it into a real world, so we all have prospective clients around the country.
Yeah.
And as Wyoming has developed the Dow, let's take the Dow.
Yeah.
So a company comes from Silicon Valley, they want to have a legally recognized Dow. And they come here, set it up, and it's going to be fully automated. It's going to have a decentralized, all members are going to participate. So you're thinking, well, you're getting past Howie, right? You're not profiting on the efforts of others. But you're thinking this is state jurisdiction here. We think you're covered in Wyoming, but you're coming only to the state. If once you pass and we started getting into this other quandary of the federal level, they're pretty much stuck. So the question is, how long we're talking about, well, we can do all these things, go to, there's a constitutional argument there. There's other, how long is this SEC going to take to have some guidance and, do sweeps, and we'll have, although not law, but some pathway. We have clients thinking of going, well, why are we here? And they're getting more advice from counsel around the country. Don't do it. Go back to Singapore. Go somewhere else, because it's so gray right now. And I think that's having a really negative impact on just the innovation and people actually pursuing not even any type of entity. So what do you think, and what are you advising your clients and your coasts in terms of, should you go for it? Some are taking the approach, well, let's file a Reg A in the get-go, get it fully decentralized, and then we'll pull back the Reg A. We'll tell the SEC we're no longer going this route. It's an interesting one, but you've already admitted there could be a securities issue here. So a lot of clients don't want to go down that road and admit it in the get-go. So where's your guidance at?
If I had the perfect answer to those questions, I'd be on my Greek yacht.
Yeah. So where are you at right now? Because there is a time crunch.
Question like onshore versus offshore, or like what type of regulatory structure?
Just waxing lyrical for a second, but yeah, so the state of things now with the unpredictability of the SEC, and you don't know which route to go, whether you follow an exemption or not. Are you telling them to just concede
I mean, so I think it really depends on what they're trying to do, right? But one of my frustrations is I talk to clients and they're like, hey, like we talked to some counsel and they have this like, incredibly elaborate dissolving Panamanian foundation that is going to, and then I'm like, all right, who are your investors? And then they start naming like all the US top. Right. I'm like, that doesn't like, it's not getting you out of pain, right? Like if you're raising money in the US and you live in New York or in Silicon Valley, like no, like, elaborate offshore structure is going to all of a sudden like be a silver bullet, right? That just doesn't work. I think the question about how do you guys do a decentralized place where the token is, so transactions in the token are no longer a security, that's like, $100 million question. The Reg A approach, I think it was not innovative, and credit goes to Wilson and Roosevelt on that super hard prospectively to say when you're no longer a security. And I think like Wilson Sonsini wrote them an opinion, and the board of Blockstack decided that they were no longer a security, but the SEC hasn't said anything, right? And they're still not like traded on Coinbase and a lot of things. And that's not even speaking about the $1.5 million that they had to spend at the get-go to get the Reg A on file, right? So I think what most people do in practice, if they're trying to do a decentralized, is they'll do like Reg D or Reg S, and then they'll just have lockups, which are like a very crude instrument, until you get to a place where you think you're like no longer secure. But yeah, I mean, there's no prescriptive like do these three things and you're there, which is like really frustrating, but also like part of what makes it exciting. Interesting practice.
Yes.
Can you talk a little bit about last year's Office of the Comptroller of the Currencies regulation that allowed banks to custodian cryptos?
Sure. I mean, number one, that was, Brian Brooks when he was there. He was a very forward-looking guy. Apparently there's going to be a new comptroller. I'll talk about that nominee in a moment. Michael Suez has not done anything necessarily to pull that apart. So obviously that's a good thing. But I'll expand on that a little bit by saying that while that is the I would say evidence of a former pro digital asset point of view within the OCC, and a very good one in my mind, because it shows that the OCC at least was an agency that was moving away from that paradigm that I used at the beginning, my little cocktail party snarky joke there about the 33 Act. That clearly was a regulator who was sort of forward thinking and sort of figuring out, okay, how's the regulatory scheme going to really work? How are we going to get digital assets within the regulatory umbrella, if you will, in a way that there could be transparency, there could be perhaps a sandbox, that sort of stuff. So I view that as a very good thing, number one. Number two, I would say that in terms of, we talked a lot about the SEC. Let's not forget the banking regulators as well. They have a huge impact on how this is going forward. They've been a little bit, the Fed isn't in the habit of making speeches like Chairman Gensler has. They're usually very much more measured. They're very quiet. They're difficult to understand. They're kind of mysterious. And they sort of operate, they don't operate quite as publicly as the SEC does. But nonetheless, they have a huge amount to say about what the liquidity in these markets is going to be. And that's a massive thing. I mean, their position paper that everyone's waiting for on stable coins is going to be extremely interesting. And obviously it's going to have a huge impact on liquidity. And so I would, and one of the things I want to make sure that we don't run out of time in doing is, and I'll plug for this, Angela said it earlier, it is really important to educate regulators and legislators on this. And it's really important to let them know that Wyoming has a model that actually has worked. It took a lot of elbow grease. It took, from everything I've heard, a lot of front work, many hours, many late hours, many all-nighters. But what has come out of it is a body of law and regulation that really kind of points the path toward how you can have a very safe paradigm and get digital assets within the regulatory umbrella in a way that makes sense for everybody. That's really important to educate people on and to de-educate them or re-educate them on some of the, the scary boogeyman about, Bitcoin mining is going to burn up the world, or, every crypto transaction is being done by a terrorist. All that is demonstrably false by way of data. And that data needs to be brought forward constantly. So anyway, sorry about that, but I wanted to make sure I got that plug in before we broke up. So let me make one more point about regulation, and then we'll. By the way, you guys are very kind to be staying after 5 o'clock. So the point is, the regulatory world right now is they're all sending signals to one another. Everyone is highly interested in this, and it's really up to folks like this that are in this room and sort of within the sound of our voice to make sure that they stay up to speed. It's an avalanche of information that is coming in every day. So, for example, the recent nominee for a control of the currency does have some fairly negative views about cryptocurrencies, and, by the way, has a paper on it. Everybody should go and read that paper and be prepared to rebut what it says. I mean, no one knows whether the nominee is going to pass muster with the Senate, but nonetheless, it's the president's nominee. You have to respect that. Have to respect her. She's obviously a very learned individual, but has some ideas that perhaps are not as fully formed or informed as they should be. And the legislators who are going to sit in judgment of whether or not that nomination goes forward ought to have information about that. And so I think it's incumbent on everybody here to sort of be willing to educate and step forward, because that part of the regulatory process, the education process, is going to be absolutely critical, mission critical.
Yeah, I mean, I just maybe would add with looking at the fight over the infrastructure bill, I think, or maybe this is hopeful thinking, but I see it as a turning point in the community's willingness to engage in like direct political discourse. Like I've talked to tons of people that after that are, forming super PACs, like getting much more like in the weeds. So I think kind of in this coming regulatory realignment, to kind of go back to where we started, I think it's very important more than ever now to like really get engaged.
Yeah, the days of this industry is going to sail somehow around the regulatory world is those days are over, and the level of involvement is going to be consistent, it's going to be persistent, and it's going to be smart and intelligent and very fact-based and data-based. And so I'd encourage everybody to get involved, because it's going to be important. So any open mic time now. Any additional questions? There is a networking event at an hour and 15 minutes, so we don't want to stand in the way of that.
Thanks very much.
One last question before we go. Speaking of politics, do you guys know, or maybe somebody in the room does, it's a pretty big political run here in Wyoming for Congress with Liz Cheney and this group of people. I don't assume that Liz Cheney has favorable views on cryptocurrency, but
She does not.
She does not. What do we know about? I mean, there's Harry Hagan. Like, where are the other candidates? Is there someone that we would say that's a friendly person to the industry and community?
Okay, good question.
No.
I mean,
I think you should. Let's start a draft.
But you raise an excellent question, and I think in considering those sorts of issues, it's a smart thing for ourselves, but also, frankly, for our kids. Who's the candidate who is most sort of forward-thinking around technology, around innovation, around? It's not like following every crazy idea that comes down the pike, but who's thoughtful about it? Who serves on the Financial Innovation Caucus or the similar caucus that's in the House? Has their office issued any statements about it, et cetera? Those are very, very good questions because it's going to be central to Wyoming's future, but it's also going to be central to the country's future. This is not going to change. I mean, it's kind of funny that in the journal today there was an article about apparently one of the last bastions of actually using papers and telephones on Wall Street is the equity capital markets desk, the syndicate desk. And there's a new digital tool that's been introduced. It's called Capital Markets something. You might know what it is. That is supposed to be revolutionizing that desk. And there's just going to be a lot of disintermediation going on, and we need to confront it because it's not going to stop. But we need to address it in a very intelligent way.
Also encourage you to reach out to like some of the trade groups and like lobbying groups, so like the Point Center and Washington Association. They I'm sure are tracking this stuff.
These are DC firms.
They're both DC based kind of lobbying groups. Yeah.
Yeah. There's the Blockchain Association. There is
Digital Chamber of Commerce.
Digital Chamber of Commerce.
And Point Center, which is more like a think tanks. All the things. Yeah.
Also, I think it would be helpful for when the trade associations that are opposed to us spread disinformation. We're really bad as an industry at responding to that. And there's just a brand new one from Bank Policy Institute today. You're going to love that. Right?
Yeah,
and it's just outright, it's got outright lies in it. And nobody calls them on it.
Yeah.
And they have succeeded in spreading some pretty defamatory misinformation about me. But nobody has challenged them on it.
Now, the other one, by the way, is the Association of Digital Asset Markets, Adam. So there are, you can kind of see it forming right now, but I wouldn't say it's as coordinated as it should be. So there should be perhaps something like I don't want to say a war room, but a rapid response function where when things come out that are not accurate, they can be pushed back on immediately.
Those are typically in other industries, it's those associations that will then have in-state counsel that will then litigate, to get ahead of this, state law versus.
It differs trade association to trade association.
Well, that's generally who is the party that takes action on behalf of a company in the state.
We're pretty good on Twitter, though. I mean, once something gets going.
That's what I was thinking.
Yeah, and that is a place. I mean, I got Matt Levine to respond yesterday. He wrote something that I thought was just outrageous in his piece the day before. Or I guess it was yesterday. He said the entire crypto industry thinks no cryptocurrencies are securities. And I pushed him on that, and he responded to me, which is great. And just to get a dialogue going on that is. When you see things like that, start calling them out. Well, it's hard for me to do that all the time, though.
Yeah.
In the position that I'm in.
Right. I think part of the struggle is or at least I live in such an echo chamber. It's like I'm talking to the same people that are so into this, and it's hard to translate that. And I think we've also, or the industry has suffered from just bad messaging. It can't be like the Silicon Valley bros coming into Washington saying, we have this magical technology, let me explain it to you idiots. And it's, decentralized, not decentralized. We need to hit things it's libertarian thing. It's international competitiveness thing. So I think we've kind of failed at connecting the message with things that Washington cares about. And we've basically been these techie, head in the clouds folks. I don't know if folks agree, but I definitely think there's work to be done, and that's
telling your regulators have fun staying poor is not a really great message.
Yeah.
that
walking into Warren's office and talking about decentralization and you don't connect those people, right? You need to speak their language much more.
Well, look, slowly but surely, good information is being compiled. So NIDA just came out with a report on Bitcoin and climate, for example, that I have it's in my laptop, not my laptop, my iPad here. I haven't had a chance to read it, but I'm sure it's quite thoughtful because they're thoughtful people. And the other thing we should keep in mind is we shouldn't be running around thinking we have challenges ahead, but we shouldn't be thinking that we have, in air quotes now, enemies, because we should be thinking about ultimately there's going to be a confluence here. Ultimately, the rivers are going to come together and hopefully create a bigger river. And so we may need to convince people on the other side who don't exactly see things that way. But there's every motivation. Look, I spent a lot of time inside banks. There's a lot of reasons for banks ultimately to come around to this technology and to this community, because it makes a lot of sense for their customers. It makes a lot of sense from the standpoint of safety. It makes a lot of sense from the standpoint of liquidity. It makes a lot of sense from the standpoint of frankly, lower costs. Now, it's not like it's an easy thing to do, because most banks don't have the kind of technology stacks that can easily accommodate this. But that doesn't mean it can't be done. It obviously can be done.
Do you see any risk from central bank stablecoins disintermediating traditional banks?
Not in a big way. I think the thing that would be a little bit difficult, it gives traditional banks a balance sheet management issue, because in times of stress, there could be a run of deposits. It's commercial bank money, right? It could be a run of deposits to what CBDCs would be, which would be central bank money, because there would be a perception that it would be safer. Now, that could mess with liquidity coverage ratios and the like. But I think the Fed could probably manage that by putting caps on CBDCs. But you'd have to be thoughtful about that for sure. Yeah. I don't think it's not a torpedo at the waterline at all. Now, Rodrigo, you might disagree with me.
I mean, you know way more about banking than I do. I'm like a securities lawyer. I do think that it's a different paradigm, right? Like if you can have a direct claim against the Fed, why do I need my bank? I think there's different ways you can structure that.
The way that they've talked about it, like forget when the IMF conference was, where they talked about stablecoins. They released a white paper in tandem with the conference. But Jay Powell, was in the first session, and they talked about, this is probably just going to be something that we issue to member banks, and that traditional banking will continue. But the crypto world looks at that and thinks like, well, the fungibility of money is going to change, because you're going to incentivize spending habits and control velocity via discounts and haircuts on your wallet with the central banks. So I don't know.
The one thing the Fed will not want to give up is control over monetary policy.
Which is why
that's for doggone sure.
They're danders up about central or stable coins.
Of course. The other thing I would mention is that is a thread that sort of gets tied up with various political considerations. So the nominee for comptroller of the currency has said that that the public should be the adults in the room in connection with setting bank policy. And obviously, that's a big statement. I'm not sure what is meant by that, but I think that this nominee may be in favor of direct Fed accounts and the like, not just CBDCs, but direct Fed accounts, which I think in an economy that has been built on private competition, having the government come in and compete with private providers of financial services doesn't strike me as maybe the best idea in the world, but it can be very, very politically popular. So that's one of those stay tuned kind of things.
Thanks, sir.
One more.
One more quick question. Is how much risk is there of cease and desists happening in active projects?
Like
where
Jersey
that
did?
suddenly freeze and then the consumers can't get their money out because there's been a regulatory action with a cease and desist?
I think that on the federal level, I wouldn't view that as a really very high chance. That's very that's sort of using a nuclear weapon to go after an ant. I don't think that I mean, if there were some belief that there was imminent losses that couldn't be replaced, perhaps. But I think that if you were to see that, it would be mostly on the state level, as New Jersey did, with respect to block 5. So
the way that I think it's a good question, and I think what it kind of fundamentally raises for me is, what are the remedies that the regulators are pushing? I'm more familiar with like the securities world, and I think the SEC is struggling with this, right? Like they brought enforcement actions against a bunch of token issuers, and then the token holders get screwed.
Right.
Like what happened to XRP holders when they brought an enforcement action against Ripple, right? And then what happened? And then you look at when they rolled up against kind of like the earlier 2017 ICO projects, like thinking about was it AirFox and Paradigm, not the Paradigm, like cannabis one. Anyways, they forced them to offer rescission, but then nobody got paid any money. So it's like, yes, you obviously need to enforce the laws, but you also need to make sure that the people you're trying to protect aren't worse off when you do so, right? Because if you're trying to protect token purchasers, and the result of your action is that they just lost a bunch of money on their tokens and are basically left without any remedy, that's not a good outcome, right? I think Hester Pierce has been very thoughtful about this and kind of pushed back a little bit at the SEC's actions.
But then on the flip side, one of the big lending platforms just got a big financing deal done in the face of all of this obvious regulatory action, which suggests the VCs don't care. They don't take it seriously.
they think there'll be a solution. And they
They'll
probably,
pay a fine and, it's a cost of doing business and they move on, right?
or that it will be a forward-looking solution and not backward-looking. And, there'll be agreements around people will register under certain circumstances, et cetera, and perhaps there'll be a fine.
And then back to my earlier point that the joke was on the people who went to get permission and waited years for it.
Yes.
Yeah.
I mean, I think the clearest example of that is compare the size of Binance to Coinbase.
Yeah.
Orders of magnitude. FTX did the same thing. Orders of magnitude.
Well, I mean, if you look at what the SEC did with Abra, FTX is doing much the same thing. It has U.S.
Their US platform is super different.
Right, but there's an article that goes into all that, how much U.S. connections it has, right?
Yeah.
So, I mean, again, now we're back to the incentive that's been laid out is don't ask for permission, ask for forgiveness.
Mhm.
And because there hasn't been equal enforcement action. Yeah, it's a strange situation.
Guys, we made it past the hour. Thank you so much.
Oh, wait a minute, no, one more in the back. We don't want to be that guy.
You already are that guy.
So this is probably an easy one to answer, actually. So it might run contrary to the very ethos of this movement, but is there any merit to the idea of self-policing to a certain extent?
Sure.
Calling out scams, calling out these sort of situations to let the authorities sort of, they're kind of handling themselves. You obviously can't do that in every scenario, but is there a place for a voice for us to join in on?
So I do think that, and when you listen to folks like Michelle Bond and Adam, and she's talking about their code of conduct, there definitely is a view that kind of a quasi SRO might be the right way to go. Now, I don't know that you could have exactly an SRO. It wouldn't be like FINRA, where basically the SEC, oversees FINRA itself. But I think organizing around standards of conduct makes a lot of sense.
I think you're starting to see it too. Like in the exchange space, there's been SROs. There's the Crypto Rating Council, which is kind of like an attempted. There's GDF, Global Digital Finance. That's more like a European-based entity, but it's also like kind of the codes of conduct. So I think you're seeing it. I don't think the regulators will look at it and be like, okay, we're done here.
They're fine. Awesome, thank you.
Yeah, thanks everyone.
Thanks.